I recently got a call from a client who's currently on federal probation asking me whether he's required to open the door to ICE agents. Of course, here's the dilemma. Should he comply and open the door? Or otherwise, would he be violating his terms of supervision? Of course, you know that if you're on supervised release, probation, or parole in the federal or state system, you have received conditions of your supervision, usually at sentencing or from the probation department. And you know that most likely you have given up certain rights. Usually you have waived your Fourth Amendment rights. So the question here, if the officers are acting without a warrant, should you comply? And today we're going to look at the case that was published this year by the Ninth Circuit. And here the officers muddied the waters between a probationary check and a new criminal investigation. And because the individual did not know his rights, never read the conditions of his supervision, he ended up paying the price. So before we go on, I want to tell you, make sure you review your conditions of supervision. Know exactly what rights you have given up and what rights you have retained. And before we go on, I want to thank you for watching me here on YouTube. If you're new to the LAWSTACHE channel, this is your opportunity to hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to lawstache.com and check out some of the merch, including the Do Not Arrest This Person t-shirts. Thanks for watching.
Quick message from LAWSTACHE. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the LAWSTACHE YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the LAWSTACHE YouTube page. That's LAWSTACHE.
Today we're discussing a Ninth Circuit case, United States versus Tyler Watson. Mr. Watson was on parole, and through a confidential informant, law enforcement figured out that he was distributing narcotics, storing them at 2 different locations, and using boxes and magnets would attach boxes full of narcotics to the undercarriage of his vehicle in order to transport them. Now, through the confidential informant, law enforcement also figured out that Mr. Watson was distributing enough fentanyl to generate about $15,000 a week in profit. Now, law enforcement, of course, spoke to Mr. Watson's parole officer and found out that he was currently registered and living with his mother, and on previous occasions, he also lived with his grandmother. So here are the 2 different locations. Of course, because Mr. Watson was on parole, he generally waived some of his Fourth Amendment rights. There were conditions of supervision. And so, in order for us to go on and discuss this case, let's take a look carefully on what rights Mr. Watson waived. What conditions of supervisions exist? Officers learned that Watson had signed an agreement outlining the terms and conditions of his parole that prohibited his use and possession of controlled substances and waived his Fourth Amendment rights. By signing the agreement, Watson consented to a search of his person, residence, vehicle, personal property, and other real property by any agent of IDOC or a law enforcement officer. Another condition in the agreement stated, I will cooperate with the requests of my probation/parole officer. Cooperation includes being truthful. If I'm detained by law enforcement, I will tell the officers that I'm on felony supervision and the name of my probation/parole officer. I will notify my probation/parole officer of any such contact within 24 hours. Now that you know the conditions of supervision, understand this. The Fourth Amendment requires the officers to have a warrant before they search or make any sort of seizures. But in this case, the officers were operating without a warrant. that were relying strictly on the conditions of supervision. And so, on the morning of Mr. Watson's arrest, officers were briefed and they were told that the idea was to surveil the house and eventually search it, and that one of the officers would pull over Mr. Watson for some sort of traffic infraction. And so that's exactly what happened. An officer observed Mr. Watson, who did not show his blinker when he was changing lanes. The officer pulled over Mr. Watson for the simple traffic infraction, and the idea was to search the vehicle, make sure there were no weapons on Mr. Watson, and get him arrested while his property is being searched. So the officers pulled him over, like I said. They searched Mr. Watson based on the conditions of his supervision because he waived his Fourth Amendment rights. They searched his vehicle, and in the meantime, the officers also went in to his mother's house where Mr. Watson was residing, the actual registered address, and they began searching that house. Now, during this time, Mr. Watson was placed under arrest. He was placed in the patrol vehicle, driven to his house, and at this point, the only time the parole officer approached Mr. Watson to retrieve Mr. Watson's cell phone and ask him for the password in order to open it up. This was the only interaction that Mr. Watson had with his parole officer. The rest of the day was always conversations between him and other law enforcement agents. So while the house was being searched, another law enforcement agent came up to Mr. Watson, who was in the patrol vehicle. He gave him the Miranda rights, explained to Mr. Watson that he did not have to answer questions and that everything he says can and will be used against him. And so, after Mr. Watson consented and said that he was willing to answer questions, meaning he waived his Miranda rights. Again, Miranda applies when you're in custody and being interrogated. There's no question about that Mr. Watson was in custody. He was handcuffed in the back of a patrol vehicle and he was not free to leave. This is a classic example of being in custody, where the individual is quote-unquote not free to leave. So he's in custody, and of course the officer is now interrogating Mr. Watson. What is interrogation? This is where law enforcement is trying to elicit incriminating statements. So after Mr. Watson agreed to speak without a lawyer, the officer told him that they believed that more narcotics are being stored at the grandmother's house, and whether that's true. Well, Mr. Watson said that was true. In fact, more narcotics would be found at the grandmother's house, and he consented to take the officers to that location and point out exactly where the narcotics are being stored. At the grandmother's house, the officers located about 4.5 kilograms of fentanyl, 2 ounces of methamphetamine, and $8,600 in cash. Mr. Watson was then charged in federal court with possession with intent to distribute fentanyl in violation of 21 U.S.C. Section 841. But Mr. Watson, at the district court level and now in the Ninth Circuit, argues that the officers violated his Fourth and Fifth Amendment rights. He says that he would have never made the incriminating statements to the police had he not been on parole. He believed that the conditions of his supervision created a penalty if he did not cooperate with law enforcement. And so he believed that he had to tell the officers that there were no more narcotics at the grandmother's house. He says that even though he waived his Miranda rights, he was compelled to waive those rights because, again, he believed that the conditions of his supervision required him to do so. The Fifth Amendment's privilege against self-incrimination generally applies only to those who claim it. However, this general rule does not apply when an individual is denied the free choice to admit, to deny, or to refuse to answer. This can occur when the government creates a situation where an individual refusal to answer the incriminating questions subjects him to a penalty. In a penalty situation, the Fifth Amendment becomes self-executing. In other words, if the state, either expressly or by implication, asserts that invocation of the privilege would lead to revocation of probation, the failure to assert the privilege would be excused, and the probationer's answer would be deemed compelled and inadmissible in a criminal prosecution. I realize this was very wordy, so here's the takeaway. In order to exercise your Fifth Amendment rights, you have to invoke your right to remain silent. So here, Mr. Watson did not invoke his right to remain silent. But the Ninth Circuit says there could be situations which we can describe as quote-unquote penalty, where the individual thinks that he has to waive his Miranda. And the Ninth Circuit gives two examples. There's a Supreme Court case, Murphy and Saechao. In Murphy, the condition said that the person on the parole, the defendant, has to be truthful with his probation officer in all matters. Now, the Supreme Court says this is not a penalty situation because even though Mr. Murphy has to be truthful, he's not required to speak at all. So the first question becomes whether he speaks or doesn't. If he does, then he has to be truthful. So this is not a penalty situation. But then we compare it to the Saechao case, where the condition was slightly different. It says that the individual has to promptly and truthfully answer all reasonable inquiries. So here, in this condition, the Supreme Court says because of that word promptly, that means that the individual has to answer questions. So now let's look back at our condition. There's a word cooperation, but the Ninth Circuit says that the particular condition says that he has to cooperate with his probation/parole officer. It doesn't say anything about other law enforcement agents. The Ninth Circuit recognizes that the officers muddied the waters because Mr. Watson had interaction with both his parole officer that day and other law enforcement agents. It was not clear to him whether he was answering to a parole check or whether this was a general criminal investigation. But the Ninth Circuit says, regardless that the waters have been muddied, it is on the parole probation individual to understand his rights. And so the Ninth Circuit says that unfortunately he is not in the penalty situation. The only time he has to answer questions and cooperate is when a parole officer is asking him questions. And here it was a law enforcement officer who was asking him about the drugs at the second location. And so because he didn't invoke his Fifth Amendment rights, the search is legal. He gave the incriminating information, and based on that information and the consent, they searched the location. So he loses in this situation. That all the items that were seized would not be suppressed and can still be used against Mr. Watson. So here's how the Ninth Circuit concludes the case. Watson was not subject to a penalty situation because nothing in Watson's agreement required that he speak, cooperate, or be truthful with law enforcement. He was properly Mirandized immediately prior to his incriminating statements, stated he understood his rights, and agreed to cooperate. And he was never told that refusing to answer officers' questions would result in the revocation of his parole or any other penalty. Because Watson's statements were not involuntarily compelled under penalty of parole violation, the district court properly denied Watson's motion to suppress. Now that we played out this scenario, let's go back to answer the question whether somebody who is on parole, supervised release, or probation has to open the door to ICE agents. Well, as you can tell, the answer is not very clear. It all depends on your conditions of supervision. So make sure you read those conditions. And if the condition says that you have to allow your parole officer to check your residence, it doesn't mean that other law enforcement agents are allowed to go in. So it all depends on the language of your supervision conditions. So I hope this was somewhat helpful. If you enjoyed this video, give it a thumbs up. If you're new to the LAWSTACHE channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to lawstache.com and check out some of the merch. Thanks for watching, and I'll see you next Wednesday for another deep dive on another criminal case.